The midday sun pressed flat and unforgiving against the concrete of the front walk, burning the pale gray surface to a dull white, and Garrett Novak stepped out of his front door into that heat, with a folder of documents held against his side and a phone already unlocked in his other hand. He was 32 years old, a residential property owner with a clear title, a paid-in-full mortgage installment record, and a mother named Ruth who had come to live with him 8 months earlier following the surgery that had taken most of the function from her left hip. The wooden access ramp he had built along the left side of the front steps was 41 inches wide, coated in non-slip composite decking, permitted by the city building office, and signed off by a licensed contractor whose paperwork sat in the second sleeve of that folder. He had built it on a Saturday in late October, and by the following Tuesday a bright orange notice had been taped to his mailbox post by someone who had not knocked on his door first. What Garrett did not do was call the number on the notice and beg. What he did instead was take a photograph of the notice, check the timestamp, slip it into the folder, and stand in his own driveway in the midday light and wait to see who would come next. She came 4 days later, and she was certain, and she had no idea what she was walking toward. Stay with this story until the end, because the document she was most confident about turns out to be the one that finishes her. Garrett had bought the house on Peregrine Court 3 years before any of this began, when the neighborhood was quiet enough that the HOA newsletter was a single folded page slid under the door once a month, with announcements about the spring mulching schedule and the date of the annual guest parking review. He had not bought it because it was impressive. It was a narrow 2-story with a detached garage set back from the left side of the property, a low brick retaining wall along the front, and a driveway that ran in a straight line from the street to the garage with a slight upward grade that leveled off near the garage apron. He had bought it because it was his, and because the title was clean, and because he had verified the covenants, conditions, and restrictions before signing anything. That detail mattered. Garrett had spent 4 years before buying the house working as a permit technician for the county planning department, and he understood the difference between an architectural guideline and an enforceable restriction with the same clarity that other people understood the difference between a suggestion and a law. He had left that job to take a position with a private firm, but the knowledge did not leave with the badge. His mother Ruth had been a practical woman her entire life, the kind of person who kept her own files, paid her own bills 2 weeks early, and had opinions about load-bearing walls. The surgery had not changed her mind about any of those things. It had only changed what she needed to get from the car to the front door without pain. The ramp had taken him one Saturday, 6 treated lumber posts, a box of exterior screws, and a conversation with the city building department that confirmed the structure required only a standard residential accessory permit, which he had applied for and received before he broke ground. The contractor who helped him install the handrail had countersigned the completion certificate. The ramp met every dimensional requirement in the county accessibility code. None of that mattered to Bridget Calloway. Bridget Calloway was 47 years old, the current Architectural Review Committee chair for the Peregrine Court Homeowners Association, and she arrived at Garrett's front walk on a Thursday morning in a red blazer worn over a white shirt, her blonde hair pinned tightly at the back of her head, and 2 people behind her who Garrett did not yet know by name. She walked with the pace of someone who had already decided how the conversation would end. She told Garrett, without preamble, that the ramp was a non-compliant structure under Section 4 of the Community Architectural Standards, that it had been installed without ARC approval, and that he had 30 days to remove it, or the association would begin levying daily fines at a rate of $100 per day, beginning on the 31st day. Garrett asked her calmly whether she had reviewed the city permit for the structure. She told him that the city permit was irrelevant because community standards were a separate and independent authority from municipal code. He answered that he understood that distinction and would be reviewing the relevant association documents himself. She told him that the standards were clear and that she had been enforcing them consistently for 3 years. Garrett said plainly that he appreciated her time, and he photographed the orange fine notice she handed him while she was still holding it, catching her hand and the notice and the date in the same frame. She left without looking back. Garrett went inside, set the folder on the kitchen table, and opened the association's full CC&R document, which he had downloaded from the county recorder's office before the meeting because he had expected her to come eventually. He read Section 4 that afternoon. Then he read the Fair Housing Act amendment that had been federal law since 1988. Then he found the page of the county recorder's database that showed every document the Peregrine Court HOA had ever filed, and he noted that the most recent version of their architectural standards had been filed in 2019, and he made a note of that date in the margin of his legal pad. The 30 days passed without Garrett removing the ramp. On the 31st day, the first $100 fine appeared on his HOA account portal. He photographed the screen. On the 32nd day, he sent a written letter to the HOA board, not the ARC, addressed to the board president by name, explaining that the ramp was a reasonable accommodation for a person with a disability under the Fair Housing Act, that the act imposed an affirmative obligation on housing associations to permit such modifications, that the association's own architectural standards contained a federally mandated carve-out for disability accommodations in Section 4, subsection C, and that he was providing formal written notice that no fine levied against this structure would be paid voluntarily, and that any attempt to collect it would be contested. He included a copy of his city permit, the contractor's completion certificate, his mother's surgical discharge paperwork documenting her mobility impairment, and a printed copy of the relevant statutory language. He sent it by certified mail with return receipt requested. He kept the receipt. 3 days later, he received a form letter from Bridget Calloway's email address informing him that the ARC had reviewed the matter and found no basis for an exemption under Section 4 because, the letter stated, the subsection C carve-out required prior ARC approval before installation, which he had not sought. Garrett read that sentence twice. He underlined it. He then pulled up the 2019 filing of the architectural standards and read subsection C in full. The subsection did not contain a prior approval requirement. It said only that modifications for accessibility purposes were permissible, provided they met municipal code and were constructed in a manner consistent with the materials used in the primary structure. His ramp used composite decking. His house's front steps were faced in composite decking. He photographed both, side by side, in the same frame. Then he drove to the office of a fair housing attorney named Priscilla Wentworth, who had been practicing housing discrimination law in the county for 19 years, and he set the folder on her desk, and he waited while she read. She told him, unhurried, that the letter from Calloway's email address was a misrepresentation of the written standard. She asked whether he wanted to send a formal demand letter or file directly. He answered that he wanted to send the letter first and give the board 30 days to correct themselves. Wentworth agreed that was the procedurally cleanest approach and drafted the demand that afternoon. The demand letter went out by certified mail the following morning. It identified the specific statutory authority, the specific subsection misrepresented in Calloway's letter, the specific fine amounts already levied, and the requirement that the association void all fines, issue a written acknowledgement that the ramp was compliant, and cease all future fine activity within 30 days, or face a fair housing complaint filed with the Department of Housing and Urban Development, as well as a civil action. It named Bridget Calloway by title and identified the form letter as a material misstatement of the written standards. Garrett had also, during the 3 days between Calloway's form letter and his drive to Wentworth's office, submitted a request through the HOA's records access procedure for all ARC correspondence and meeting minutes relating to any fine or notice issued in the past 3 years. That request was his right under state law, and the association had 21 days to produce the records. The response came on the 19th day, and it was incomplete. The records produced showed 12 ARC enforcement actions over 3 years, with full correspondence files attached for 10 of them. The 2 missing files corresponded to the 2 cases Garrett had already identified from online public records searches: a family on Sorrel Lane who had installed a grab bar on an exterior stair rail the previous year, and a single resident on Pheasant Drive who had installed a threshold ramp at his front door 18 months before that. Both had paid fines. Neither had contested. Garrett compiled this information into a single document with dates, fine amounts, and the names of the affected properties, and he sent a copy to Wentworth and kept the original in the folder behind a tab divider he labeled third party. The 30 days allowed by the demand letter expired on a Wednesday. No response came. Wentworth filed the HUD complaint the following morning and opened the civil action in county court that afternoon. The court date arrived 6 weeks later, and the morning of the hearing the sun was again pressing hard on the Peregrine Court sidewalk when Garrett walked to his car with the folder, now 4 inches thick, tucked under his arm. He arrived at the courthouse 40 minutes early. Bridget Calloway arrived 12 minutes before the hearing, still in the red blazer over a white shirt, still with her hair up, accompanied by the association's retained counsel, a man named Dennis Harford who had the practiced patience of someone accustomed to HOA disputes settling before a judge got involved. Harford opened by arguing that the association had acted within its governing documents and that the prior approval requirement, while not explicitly stated in subsection C, was implied by the general ARC review process outlined in Section 2. The judge, the Honorable Marion Slade, a woman of 60 who had been on the county bench for 14 years, asked Harford to direct her to the specific language in subsection C that imposed a prior approval requirement. Harford said the language was implicit. She told him flatly that implied terms in a restrictive covenant were not enforceable against a property owner in this jurisdiction without explicit written statement, and she asked him to try again. He said the association's long-standing practice established the requirement. She asked for the written practice policy. Harford looked at Calloway. Calloway looked at the table. Wentworth then placed on the record the complete text of subsection C, the complete text of Garrett's city permit, the contractor's completion certificate, the surgical documentation establishing Ruth's disability, the misrepresenting form letter, the 3-year fine history including the 2 prior accessibility cases, and the certified mail receipts showing the dates every document had been delivered and the dates no response had come. She also placed on the record with a short explanatory note that the association's records request response had been materially incomplete, which under state statute constituted a separate violation. Slade reviewed the file for 11 minutes without speaking. Then she told Harford that she was voiding all fines, that she found the misrepresentation of the written standard in the form letter troubling, and that the prior accessibility cases presented a pattern that she was referring to the State Civil Rights Office. She told him the hearing had taken 20 minutes and that the association would bear Garrett's attorney fees. Harford said he understood. Calloway said nothing at all. Wentworth made a note in her own folder, and Garrett sat quietly and let the room come back to its normal temperature. The referral to the State Civil Rights Office produced an investigation that ran for 4 months. The investigator, a methodical woman named Sandra Britton who had spent 11 years in the office, contacted the 2 prior claimants independently. The resident on Sorrel Lane, whose name was Hector Ewan, confirmed that he had paid the fine because he had not known he could contest it. The resident on Pheasant Drive, a man named Calvin Morse, said something more useful. He told Britton that when he had initially questioned the fine, Calloway had told him, verbally, that the association had never lost an enforcement case and never would. Morse had written that down in a personal journal on the same day. He produced the journal. Britton added it to her file. The investigation also requested the complete board minutes for all regular meetings during Calloway's 3-year tenure, and within those minutes the investigator found 11 references to ARC enforcement actions with no corresponding record requests fulfilled and no board votes recorded, which meant Calloway had been issuing fine notices under the ARC's authority without bringing them to a board vote, as the association's own bylaws required. The fines had been, in the technical language the investigator used in her written finding, unilaterally issued by a committee chair without governing board authorization, which rendered them not merely excessive, but void as a matter of association procedure, independent of the federal question. That finding was forwarded to the full board. The full board, minus Calloway, who resigned by email on the day the investigators' preliminary findings were shared with the board president, voted to settle the state civil rights matter by refunding the fines paid by Ewan and Morse with interest, posting a written apology on the association's own community portal, and retaining an outside fair housing consultant to review and rewrite the architectural standards within 90 days. The new standards arrived in 86 days. Subsection C was rewritten to explicitly state, in plain language, that no prior approval was required for disability accommodations that met municipal code, and that such modifications were affirmatively permitted. The HOA's retained attorney Harford declined to renew his contract with the association at the end of the calendar year, and did not comment publicly. A woman named Teresa Ogle, who had been the ARC's secretary for 2 years, and had quietly retained copies of every meeting agenda and every piece of correspondence Calloway had ever issued from the committee, provided those copies to the investigator in the 3rd week of the investigation without being subpoenaed. She had kept them, she told Britton, because she had understood from early in her tenure that the records might one day matter, and she had wanted to be on the right side of whatever eventually happened. Ruth Novak continued to use the ramp every day. Garrett had added a small brass weather cap to the top of each handrail post the spring after the court hearing, not as a statement but because the exposed post ends had been bothering him since the day he built it, and with the matter settled he finally had the time to finish the details properly. The cedar of the handrail had begun to silver gently in the sun, the way good wood does, and the composite decking remained true. The orange notice that had started all of it was in a plain manila envelope in the second drawer of his filing cabinet, not framed, not displayed, just kept, because Garrett was the kind of person who believed that a document which had once been used against you was best preserved in exactly the condition it was found. The neighborhood had gone on in its ordinary way, quieter in certain respects. The new ARC committee met quarterly, and issued written agendas and kept complete minutes, and had not issued a single unilateral fine notice in the year since the rewritten standards took effect. Hector Ewan, who had paid $200 he had never owed, used his refund to buy lumber and built a raised garden bed along his back fence, which the new committee reviewed and approved in writing within 10 days. Calvin Morse had no further dealings with the association, and preferred it that way. Sandra Britton closed her case file and moved on to the next one. Priscilla Wentworth added the matter to the section of her firm's record that she privately called the clean wins, the cases where no appeal came, and no settlement was offered below full remedy, and no one had to argue about what the document actually said, because the document had spoken plainly enough on its own. Garrett drove to the building department the following autumn and pulled the permit card for the ramp out of the completed file, just to hold it for a moment, and then he put it back where it belonged. An assumption can operate as authority for only as long as the person it targets declines to read. Bridget Calloway's resignation email had arrived at 7:43 on a Tuesday morning, and the board president, a man named Frank Osei, who had been in the role for 14 months, and had spent most of that time deferring to Calloway's institutional confidence, read it twice before forwarding it to the rest of the board without comment. HOA was 51 years old, a former logistics coordinator who understood the cost of a supply chain built on a single, unverified assumption, and he had understood for some weeks that the association's enforcement structure had been exactly that. He had not known the specific dimensions of the problem until Britain's preliminary findings arrived in his inbox, but when they did, he recognized the shape of it immediately. A process that had been allowed to run on one person's authority because no one had tested whether that authority was real. He called Wentworth's office the same afternoon the resignation arrived and told her, almost sheepishly, that the board intended to cooperate fully and that he personally wanted to understand what procedural safeguards would be required going forward. Wentworth told him that the settlement terms would address that, and that cooperation now was noted and would be noted in the investigator's file. HOA thanked her and did not ask for anything in return for the cooperation, which Wentworth also noted. The full board met 4 days after the resignation, in a session that lasted 3 hours and 20 minutes and was the longest regular meeting in the association's 12-year history. The minutes, kept this time by a newly appointed recording secretary who understood that every word would be reviewed, ran to 19 pages. The board voted to accept the settlement terms unanimously. They voted to commission the rewrite of the architectural standards by an outside consultant, rather than by any current committee member, and they voted to post the agenda, the settlement summary, and the written apology on the community portal within 5 business days. The apology was 2 paragraphs long and said plainly that the association had issued fine notices without proper board authorization, had misrepresented the content of its own governing documents in written correspondence, and had failed to fulfill a records request in complete form, and that these failures had caused measurable harm to residents who had done nothing wrong. It did not use the phrase regrets any confusion, which Wentworth had specifically noted should not appear in any form, because confusion had not been the mechanism of the harm. The board had initially drafted a version that used that phrase. HOA had removed it himself before sending the draft to Wentworth, and she had approved the revised language without further comment. Garrett read the posted apology on the community portal on a Friday evening, sitting at the kitchen table with a cup of coffee that had gone slightly cold while he was reading the board minutes attached to it. Ruth was in the next room, and he could hear the particular rhythm of her walker on the hardwood floor, the measured, unhurried sound of a woman navigating her own home on her own terms. He had not told her all of the procedural details as they unfolded, partly because she had her own medical appointments and her own fatigue, and did not need a running account of a bureaucratic dispute, and partly because Ruth had told him early on, in that direct way she had of foreclosing a conversation she considered already settled, that she trusted him to handle it and did not need to be consulted at every step. He had handled it. He closed the portal page, finished the cold coffee, and went to check whether she needed anything before the evening news. The State Civil Rights Office's final written finding was issued 43 days after Britain closed her investigation, and it ran to 27 pages. The first 11 pages documented the factual record, the dates of the fine notices, the specific language of Calloway's form letter alongside the specific language of subsection C, the records request and its incomplete response, the prior cases involving Ewan and Morse, and the board minutes showing the absence of authorization votes for any of the 11 enforcement actions Calloway had taken during her tenure. The 12th page noted that the journal entry produced by Calvin Morse, documenting Calloway's verbal statement that the association had never lost an enforcement case and never would, was consistent with a pattern of deliberate procedural suppression rather than administrative error. The finding did not use the word deliberate lightly, and its appearance in the formal document meant something specific in the Civil Rights Office's own precedent framework. It elevated the matter from a compliance failure to an intentional act, and that distinction carried consequences that a compliance failure would not. The remaining pages itemized the required remedies, the monitoring obligations placed on the association for a period of 2 years, and the referral of Callaway's specific conduct to the County Bar Association's Ethics Review Panel, not because Callaway was an attorney, but because the County Bar maintained a parallel civic accountability review process for community association officers, a provision that almost no one outside that office knew existed, and that had been used only 4 times in the preceding decade. Callaway received the referral notice by certified mail at the address she had listed as her primary residence in the association's officer directory. There is no record that she responded to it within the initial 30-day window. Priscilla Wentworth had spent 19 years watching people discover too late that a quiet person with a complete file was a different kind of opponent than the ones they were accustomed to. She had seen the pattern often enough that she kept a short handwritten list in the inside cover of each active case file, itemizing the moments where the antagonist had made their position worse, by acting rather than verifying. In Garrett's file, that list had 4 entries by the time the formal reckoning concluded. The first was the form letter misrepresenting subsection C. The second was the incomplete records production. The third was the failure to respond to the demand letter within the allowed time. The fourth, and the one Wentworth had underlined, was the board minutes themselves. Callaway had attended every regular board meeting for 3 years, had referenced ARC enforcement actions in her committee updates at 9 of those meetings, and had never once brought a fine authorization to a board vote, which meant that for 3 years the minutes had been building, 1 meeting at a time. A record that documented her own unauthorized conduct in her own committee chair's summary, written in her own submitted language, preserved in the association's own files, and available to any resident who submitted a records request in proper form. The instrument of the enforcement had become the evidence of the overreach. Wentworth did not find this ironic. She found it typical. Hector Ewan spent the refund on the lumber, as noted, but he also did something that no one had asked him to do, and that Garrett only learned about 3 months after the settlement was finalized. Ewan had printed a 1-page plain-language summary of the Fair Housing Accommodation provision, the specific subsection of the federal statute, the requirement that homeowners associations permit disability modifications meeting municipal code, and the procedure for contesting a wrongful fine, and he had left a copy in every mailbox on Peregrine Court and the 3 adjoining streets on a Saturday morning in early spring. He had not attributed the summary to anyone or attached his name to it. He had simply folded each copy once, placed it in the mailbox, and gone home. Garrett found out about it when a neighbor he had spoken to perhaps twice in 3 years stopped him at the end of the driveway one afternoon and said plainly that she had not known any of that, and that she thought it was important that people knew. Garrett told her he agreed, and that was the extent of the conversation. He did not ask where the summary had come from. He had a reasonable idea. Teresa Ogle, who had kept the copies of Callaway's correspondence through 2 years of committee service and had produced them to the investigator without being subpoenaed, was asked by the reconstituted ARC whether she would be willing to serve as its interim chair while the new standards were being drafted. She said she would, provided the committee adopted a written meeting protocol and posted its agendas publicly before each meeting. The board agreed to both conditions without deliberation. She served as interim chair for 7 months, oversaw the adoption of the rewritten standards, drafted the new written protocol herself in clear numbered paragraphs, and then declined reappointment, telling Osei that she had done what she came to do and preferred to return to being a regular homeowner. Osei told her the board was grateful. She told him almost sheepishly that gratitude was not what she was looking for, and that a functional process was sufficient. The new committee operated under her protocol from the first meeting after her departure, and the protocol held. Ruth Novak used the ramp in all weather. In the first winter after the court hearing, Garrett added a pair of rubber edge guards along the base of the ramp where it met the front walk, because in wet weather there was a slight gap that collected debris, and he did not want her to catch the tip of her walker in it. He did this on a Saturday afternoon in November, kneeling on the composite decking in the flat gray winter light, with a tube of exterior adhesive and a utility knife, working carefully along the seam. She watched from the doorway for a few minutes, and then told him the edge guards were a good idea, and went back inside. He had not asked her opinion. She had offered it because she considered it relevant. He agreed, and the exchange was complete. The ramp had been in continuous use for 19 months by that point, and it had performed exactly as designed. The handrail had silvered further, and the composite surface had weathered to a slightly warmer tone than when it was new, and the brass weather caps on the posts had developed the shallow greenish patina that brass develops outdoors when no one is polishing it, which was the appropriate condition for a working structure on a working property. The county planning department added the ramp's permit card to its completed and inspected archive in the ordinary course of business, filed under the address, cross-referenced to the contractor's license number, and available on the department's public search portal to anyone who wanted to verify that the structure had been properly authorized before it was built. Garrett knew this because he had worked in that department and understood how the filing worked, and he checked once, 6 weeks after the court hearing. Not because he doubted it, but because he was the kind of person who verified things he already knew when the stakes had recently been high. The card was there. The permit number matched. The inspection sign-off was dated 3 days after the contractor's completion certificate, which was the correct sequence. He closed the browser window and did not check again. Some things, once verified, do not require a second verification. The ramp was one of them. Frank Osei ran the following year's annual meeting with an agenda distributed 14 days in advance, a recording secretary who published the draft minutes within 72 hours, and a Q&A period at the end that ran 40 minutes, because people had questions they had not previously felt invited to ask. Several of those questions were about the architectural standards and about what residents could do if they received a notice they believed was incorrect. Osei answered each one by directing people to the written standards and to the records request procedure, and to the state's homeowner rights hotline, the number for which he had printed on a half-sheet insert tucked into each copy of the agenda. No one at the meeting used the word accountability, because the meeting itself was the demonstration of it, and no one needed to name what was already visible. Garrett attended for 40 minutes, asked no questions, and left before the Q&A ended because Ruth's last physical therapy appointment of the week had been rescheduled to that evening, and he needed to be home when the car arrived. He had submitted a written question in advance, through the form Osei had created for that purpose, asking only whether the new ARC protocol had been posted to the community portal in its complete form. Osei confirmed at the meeting that it had been, and that the confirmation was in the minutes. The written question and the answer both appeared in the published draft 2 days later. Garrett read the draft on a Thursday morning before work and filed it in the folder behind a tab he had labeled Resolved, which was the last tab in the folder and the thinnest, containing only 2 pages. An assumption can operate as authority for only as long as the person it targets declines to read. Calloway had assumed that Garrett would not read the standard, or that if he read it he would not understand it, or that if he understood it he would not find the will to act on what he understood, and each of those assumptions was a smaller and more fragile structure than the one before it, resting on nothing more solid than the last. She had been enforcing that fragility as though it were stone for 3 years, and it had held because no one had pushed against it with a complete file, and a folder of certified mail receipts, and a working knowledge of what the written words actually required. When someone finally did, the structure came down in the order it had been built, the outermost assumption first, then the one beneath it, then the one beneath that, until there was nothing left but the written document itself, which had always said what it said and had never required her interpretation to mean anything at all.